Stop! Before you sign any nursing home paperwork, there's one hidden section that could put your personal savings, Social Security income, and retirement security at risk. And most families don't even realize it until it's too late. In today's video, I'll reveal the truth about the dangerous responsible party trap, explain what it really means for seniors and their loved ones, and show you the costly mistake that could drain thousands of dollars from your nest egg. Make sure you stay until the very end because the final warning could protect your retirement from a financial nightmare. And if you care about protecting your Social Security benefits, staying informed about pension payment updates, retirement policy changes, and financial challenges affecting seniors across the United States, subscribe now and join our community. This channel is dedicated to helping retirees and future retirees stay one step ahead. Imagine this. You've just received a call that changes everything. Your mother has fallen. She's in the hospital. The doctors are talking about rehabilitation and then long-term care. You're scared, overwhelmed, and desperately trying to figure out what to do next. And then, just hours or maybe days later, someone slides a thick stack of papers across a table toward you and says, "We just need your signature here before we can get her settled in." You're exhausted. You're emotional. You just want your mom to be safe, so you sign. And in that moment, you may have just made one of the most financially dangerous decisions of your life. Not because you're careless, but because nobody warned you about the two words buried inside that contract: responsible party. This video is that warning. What I'm about to walk you through is something that elder law attorneys see destroy families' finances every single year. And yet almost nobody talks about it openly. Nursing home contracts are not simple admissions paperwork. They are legally binding documents that can contain language designed, sometimes intentionally, sometimes just through years of legal tradition, to shift financial responsibility from the resident onto the person doing the signing. And that person is often a loving son or daughter who had absolutely no idea what they were agreeing to. Let's start at the very beginning, because understanding the danger requires understanding how nursing home billing actually works. When someone enters a skilled nursing facility, the expectation, legally and ethically, is that they pay for their own care using their own resources. That might mean private savings, long-term care insurance, or eventually Medicaid, which is the government program that pays for nursing home care once a person has spent down most of their assets. The critical legal principle here is that you, as an adult child or family member, are not automatically responsible for your parents' bills. This is not how it works in the United States. Federal law, specifically the Nursing Home Reform Act, actually prohibits nursing homes from requiring a third party to personally guarantee payment as a condition of admission. Read that again. It is against the law for a nursing home to make your personal guarantee a requirement for your parent to get a bed. But here's where things get tricky, and here's where so many families get caught. The law prohibits them from requiring it. It does not prohibit them from asking for it. And there is a universe of difference between those two things. When you sit down and sign a contract that includes responsible party language, you may be voluntarily agreeing to something that they could not have legally forced on you. The nursing home hands you a document, you sign it without reading the fine print, and suddenly you've created a contractual obligation that didn't have to exist. You've essentially done their legal work for them. So what exactly does responsible party language look like? It can take many forms, and that's part of what makes it so dangerous. Sometimes the contract says you are agreeing to use the resident's funds to pay for their care, which sounds reasonable and is generally fine. But other versions of these clauses go much further. They may state that you personally guarantee payment if the resident's funds run out. They may say you are responsible for applying for Medicaid in a timely manner, and if you fail to do so, for any reason, you become personally liable for the bills that Medicaid would have covered. Some contracts even include language saying that if you transfer any of the resident's assets inappropriately, you owe the nursing home whatever those assets were worth. Now, that last one might sound fair, but the problem is that the nursing home gets to define inappropriate, and their definition and the law's definition are not always the same thing. The financial numbers here are not small. We are not talking about a few $100s of exposure. The average cost of a semi-private room in a nursing home in the United States is now well over $9,000 per month. A private room frequently runs $12,000, $14,000, or more, depending on where you live. If your parent stays in a facility for 2 years, which is not unusual, you are looking at bills that can exceed $200,000. If a nursing home believes you are the responsible party and that you owe them money, they will sue you. And they often win because you signed a contract. This is the part of the conversation where people often push back and say, but I didn't have a choice. They needed to be admitted immediately. And I understand that feeling completely. But here's what you need to know. You almost always have more time than you think. A hospital cannot discharge a patient to a nursing home without appropriate planning. A nursing home that refuses to admit a Medicaid-eligible resident because you won't sign a personal guarantee is actually violating federal law. You have rights in this situation, even when it doesn't feel like you do. The pressure to sign immediately, right now, before your parent can get a bed, is often a tactic, not a hard legal requirement. So what should you actually do when you're faced with a nursing home contract? The first and most important thing is to slow down. Even if it feels impossible, try to buy yourself 24 to 48 hours before signing anything significant. Use that time to get an elder law attorney, not a general family lawyer, but someone who specifically practices in elder law and Medicaid planning to review the contract before you sign. Many elder law attorneys offer consultations, and some will review a contract for a flat fee that is a tiny fraction of the liability you might be taking on if you sign the wrong thing. When you or your attorney reviews the contract, there are specific things you need to look for and address. You want to find every place the document refers to you as responsible party, guarantor, or financially responsible individual. You want to understand exactly what obligations those labels create. Are you being asked to manage the resident's funds on their behalf, which is normal and fine? Or are you being asked to personally guarantee payment if those funds run out, which is dangerous and which you should refuse or negotiate out? There is a meaningful difference between being the person who writes checks from mom's account and being the person who owes money when mom's account is empty. Here's something that surprises a lot of people. Nursing home contracts are negotiable. The facility hands you a stack of papers and it feels like a take it or leave it situation, like signing a lease or a cell phone contract where there's no room to push back. But that's not actually true. You can cross out language, you can request modified versions of specific clauses, you can sign with written notations that limit your obligations. Will every facility cooperate? No. Some will push back hard. But many will negotiate, especially if you make clear that you understand your rights and are not going to be pressured into signing away your financial future. A facility that categorically refuses any negotiation on a contract that contains illegal or highly aggressive language is a facility that is telling you something important about how they operate. Now let's talk about Medicaid, because this is where the responsible party trap has another layer that catches people off guard. When a nursing home resident's private funds are exhausted, the expectation is that they will apply for Medicaid to cover the ongoing cost of care. This process involves a detailed financial review going back 5 years, what's called the Medicaid look-back period. During that review, the government examines every significant financial transfer the resident made to determine whether assets were moved in order to qualify for Medicaid more quickly. If they find transfers that look like that, they impose a penalty period during which Medicaid will not pay for care. Here's where the responsible party language in a contract can turn into a financial catastrophe. Some nursing home contracts include clauses that make you, the signing family member, responsible for paying the facility during any Medicaid penalty period. So imagine this scenario. Your parent gave money to their grandchildren over the past few years as gifts. Completely normal, completely loving, completely legal in most contexts. But under Medicaid rules, those gifts created a penalty period. During that penalty period, Medicaid won't pay. Your parent has no money, and you signed a contract saying you'd cover any gaps. Now you owe the nursing home tens of thousands of dollars for something that happened before your parent even entered the facility, for a transaction you may not have even known about. This is not a rare edge case. Elder law attorneys see this pattern regularly. And the heartbreaking part is that with proper advanced planning, much of this is avoidable. Medicaid planning, done correctly and ideally years before a crisis, can protect significant family assets while still ensuring your loved one qualifies for benefits. But crisis planning done under pressure, with a pen hovering over a nursing home contract, is a completely different situation. The options narrow dramatically when you're reacting to an emergency rather than preparing ahead of it. Let's talk about what happens after someone signs one of these contracts and then something goes wrong. Maybe the resident runs out of money. Maybe there's a Medicaid delay. Maybe the family made some financial decisions that the nursing home now considers to have been improper. The nursing home's billing department contacts you. They tell you that you owe money, sometimes significant money. What do? The first thing is, do not pay anything and do not agree to anything without consulting an attorney. What you signed matters enormously, but so does how it's interpreted, whether the language was enforceable in the first place, and whether the facility actually followed the law in how they obtained your signature. Courts have found in favor of families in these situations when the contract language was overly broad, when the facility pressured someone into signing under duress, or when the clause violated federal law against requiring personal guarantees. None of that means you'll automatically win if this happens to you, but it does mean that a bill from a nursing home is not necessarily a debt you legally owe, and you should treat it as something to be evaluated by a professional rather than something to be paid immediately. There's also a dimension of this that doesn't get talked about enough: the emotional pressure. When you're dealing with an aging parent, you are often simultaneously managing grief, fear, logistical chaos, family disagreements, your own work and home life, and a healthcare system that feels overwhelming and impersonal. Nursing home contracts get signed in that context. The facilities know this. The best ones genuinely want to work with families and are transparent about what they're asking you to sign. But others rely on the fact that you are not in a position to read 30 pages of legal language carefully. They rely on exhaustion and urgency to get signatures that might not hold up if people had more time and better information. So here is what I want you to take away from everything you've heard today. The moment you suspect that a family member may need nursing home care, even if that day seems far off, is the moment to consult an elder law attorney. Not when they've already fallen. Not when you're sitting in a hospital discharge meeting. Now, while there's time to plan. An elder law attorney can help you understand Medicaid rules in your specific state because they vary considerably. They can help you understand what planning strategies are available and which ones might create problems down the road. They can review any contracts before you sign them and negotiate language that protects you while still allowing your loved one to receive the care they need. And if you find yourself in a situation where you have no time, where the crisis is now and the contract is in front of you, remember that you have the right to ask for time to have it reviewed. You have the right to cross out clauses that make you a personal guarantor of payment. You have the right to sign as an authorized representative of your parent without personally assuming their debts. You have the right to say no to language that is designed to shift financial responsibility onto your shoulders. These rights don't disappear because someone is handing you a pen and looking at you expectantly. The nursing home industry provides an essential and often deeply caring service to millions of families. Most of the people who work in these facilities are compassionate professionals doing difficult work. But the contracts those facilities use are written by lawyers whose job is to protect the facility's financial interests. Nobody in that room is protecting yours. That's your job. And now that you know what to look for, you're in a much better position to do it. So be involved. If this video helped you, please share it with anyone who has an aging parent, anyone who is currently navigating long-term care decisions, or anyone who might find themselves sitting across a table from a nursing home admissions coordinator in the future. This is exactly the kind of information that should be common knowledge and almost never is. Leave a comment below if you have questions or if you've dealt with a situation like this yourself. Your experience might help someone else who is going through it right now. And if you want to go deeper on Medicaid planning, elder law, or protecting your family's assets as you navigate the long-term care system, subscribe so you don't miss what's coming next.